students, the topic for the day is Right to Privacy in the Absence of Data Protection Regime, a Critical Study. Introducing the topic, the Digital Personal Data Protection Bill 2023, which was introduced in the Lok Sabha on August 3, 2023 by the Minister of Electronics and Information Technology, has been passed by the Parliament, that is the Lok Sabha, on 7th August 2023 and unanimously by Rajya Sabha on August 9th 2023, and it has further received the presidential assent on August 11, 2023. The previous personal data protection bills of 2019 and 22 being ascribed to numerous amendments laced with several issues relating to data localization, transparency, compliance, intensive, etc., had been withdrawn by the central government. The said bill came into being after the Supreme Court in Justice K.S. Puttaswamy versus Union of India, the cases of 2017, upheld the right to privacy as a part of fundamental right, that is right to life, enshrined under Article 21 of the Indian Constitution, and had suggested to put in place of an act regime for protection of personal data. Objectives of the Digital Personal Data Protection Act 2023. The primary objective of the Act is to establish a comprehensive framework for the protection and processing of personal data. The Act provides for the processing of digital personal data in a manner that recognizes both the rights of the individuals to protect their personal data and the need to process such personal data for the lawful purposes and matter connected therewith or incidental thereto. This Act shall apply to the processing of personal data in India, including both the online and digitalized offline data, and shall further extend to processing of such data outside India relating to the offering of goods or services in India. The Act also lays the foundation for various other laws such as Digital India Act and other industry specific laws around privacy and data protection to augment India's march towards the adoption of artificial intelligence and other future technologies while protecting personal data. This Act may also aid Indian businessmen to enhance collaboration with other business located internationally under reciprocal arrangement while safeguarding personal data. Notably, the Act is the first ever central law in India to use her pronoun while referring to individual. Key provisions of the Act. First is the applicability and scope of the Act. The Digital Data Protection Act governs the processing of digital personal data within India in two scenarios. Number 1, when such data is collected from the data principal in digital format, or when initially collected in a non-digital form and subsequently digitalized. Thus, the Data Protection Act shall not apply to processing of personal data in non-digitalized form. It is clearer and narrower than the 2022 bill, which did not apply to non-automated processing and offline data. Moreover, the scope of the law has been extended. It now has an extraterritorial application to encompass the processing of digital personal data beyond India's border, if it pertains to the provision of goods or services to data principals located within India. Notably, the Digital Data Protection Act does not explicitly address whether its provisions are applicable to processing of personal data belonging to data principals situated outside India. Unlike the GDPR, which confines its applicability to the processing of personal information of the individual physically present within the European Union or EU citizens, the Digital Data Protection Act adopts a broader approach. It does not limit the definition of data principal to individuals within India's boundaries or solely to Indian citizens. This could potentially lead to ambiguity regarding the full scope of the Digital Data Protection Act's jurisdiction. The resolution of this ambiguity concerning the DPDP Act's extraterritorial application hinges on the interpretation that the central government eventually provide, most likely in the rules that would be framed under the Digital Protection of Data Act. Exemptions for startup and transitive provisions. Within the outlines of the Act, a distinct focus emerges on accommodating the dynamic landscape of the startups. In addition to exemptions granted to the state, its instrumentalities, research and statistical purpose, the Digital Protection of Data Act introduces a tailored approach, proposing certain provisions for potential exemption for startups. This strategic measure recognizes the distinct challenges and evolving nature of startups with the intent to nurture innovation while upholding robust data protection principle. Personal data. A novel term, digital personal data, has been introduced within the Digital Personal Data Protection Act, signifying the personal data presented in a digital form. This helps clarify the scope of implementing Act to be passed and distinguishes it from personal data that is otherwise defined. The Data Protection Act confines its coverage to processing of personal data defined as any data pertaining to an identifiable individual. Notably, the distinction between sensitive personal data and critical personal data present in all prior iterations of the draft bill up to the 2022 version has been discarded in the Digital Personal Data Protection Act. This shift signifies a departure from the previous framework and merits close examination in terms of its implications for the data protection and privacy concerns. An obligation has been placed on data fiduciaries by the Digital Personal Data Protection Act to safeguard the personal data in their possession by implementing reasonable security measures to prevent breaches. In the event of a data breach, the data fiduciary is mandated to notify both the board and the affected data principals. However, the specific manner of notification is left to be prescribed. It is worth noting that the Data Protection Act does not specify the exact standard for the reasonable security measures, which although is currently covered under the SPDI rules and section 43A of IT Act. Despite this, significant penalties are imposed for non-compliance, resulting in a personal data breach. Processing of personal data. The Digital Personal Data Protection Act meticulously outlines the scope of processing by denoting it as a wholly or partly automated operation or a series of operations conducted on digital personal data. This encompassing definition encompasses various actions including collection, recording, organization, structuring, storage, adaptation, retrieval, utilization, alignment, combination, indexing, sharing and disclosure through transmission or other means. Furthermore, the concept extends to encompass operations such as restriction, erasure or destruction of data. When it comes to processing the personal data of a child, the Digital Personal Data Protection Act requires verifiable parental consent, although it does not explicitly define verifiable consent. The central government has the authority to exempt certain data fiduciaries from this requirement by lowering the age limit for parental consent, providing the processing is considered safe. Additionally, data fiduciaries must avoid processing personal data likely to have a detrimental impact on a child's well-being. The transfer of personal data to countries outside India is also permitted under Digital Personal Data Protection Act unless explicitly restricted by the central government. It is noteworthy that the definition of processing closely mirrors the definition of processing outlined in the GDPR. However, a subtle divergence exists in the fact that while the GDPR's definition encapsulates both automated and specific non-automated operations, the DPDP Act confines the scope of processing exclusively to automated operations. This distinction, while seemingly subtle, could have consequential ramifications for the data processing landscape, necessitating a comprehensive analysis of the potential effect in practice. The 2022 bill outlined certain categories of personal data processing exempt from its purview. In contrast, the DPDP Act eliminates most exemptions introduced by the 2022 bill, save for the exemption related to personal data processed by an individual for personal or domestic purposes. Furthermore, the DPDP Act introduces an additional exemption excluding from its scope personal data that has been publicly disclosed by the data principal or any other party obligated by Indian law to make such personal data accessible to the public. Data principal. The concept of data principal has undergone a substantial expansion. It not only encompasses individuals but also includes parents or lawful guardians of children to whom the personal data pertains. Moreover, the definition has been extended to incorporate lawful guardians of the persons with disability. While the term person with disability lacks a precise explication within the DPDPB, it is notable that the Right of Persons with Disability Act 2016 forms the foundational legislation in India for recognizing the entitlements of individuals with disabilities. Under it, a person with disability is defined as someone possessing enduring physical, mental, intellectual or sensory impairment that, when compounded by societal barriers, impede their equitable participation in society akin to their peers. Under the DPDP Act, certain rights of data principals may be highlighted. First, right to information about personal data. Second, right to correction and erasure. Third, right of grievance redressal. And fourth, right to nominate. As such, data principals have the right to know a summary of the personal data processed, the identities of entities with whom their data has been shared and the categories of personal data shared. Additionally, data principals can request correction, completion, updating or erasure of their personal data processed by a data fiduciary. The data fiduciary must make necessary corrections and updates. Erasure can be denied if retention is required by law. The DPDP Act also casts responsibility on the data principal to not impersonate another person or suppress information when applying for any document or proof from the state and to provide only authentic information while exercising their right to data erasure. Data principals shall have the right to have readily available measures to grievances redressal provided by a data fiduciary in respect of any act or omission of such data fiduciary regarding the performance of its obligation in relation to the personal data of such data principals or the exercise of her rights. They can also nominate an individual to exercise their right upon their death or incapacity. Data fiduciaries. Data fiduciaries are defined as any person who alone or in conjunction with other persons determine the purpose and means of processing personal data under DPDP Act. The Digital Person Data Protection Act outlines specific legitimate uses that permits data fiduciaries to process personal data without explicit consent. One instance is when a data principal voluntarily provides a personal data while availing or seeking a service and has not indicated non-consent. Legitimate use also extend to processing data to comply with Indian laws or foreign laws in cases involving contractual or civil claim. Data fiduciaries are also required to cease retaining personal data when it becomes reasonable to assume that the purpose for which the data was collected is no longer being served and its retention is no longer necessary for legal or business reasons. The Digital Personal Data Protection Act prohibits data fiduciaries from engaging in tracking, behavioral monitoring of children or targeted advertising directed at children. Originally applying only to guardian data fiduciaries, this prohibition now extends to all type of data fiduciary. This measure safeguards children's privacy and prevents their exploitation for commercial gain, emphasizing the Digital Personal Data Protection Act's dedication to protecting children's digital well-being. Significant data fiduciaries. The Digital Protection Data Act allows the central government to have the authority to classify certain data fiduciaries or classes of them as significant data fiduciaries. This classification is based on factors such as data volume, sensitivity, risk to data principles, electoral democracy and the state security. The 2022 bill allowed the government to also consider other factors, but this has been removed. Significant data fiduciaries must fulfill additional obligation, including appointing a data protection officer based in India, engaging an independent data auditor for compliance evaluation, conducting data protection impact assessments and undergoing periodic compliance audit. Non-compliance with these obligations can result in substantial penalties extending up to rupees 250 crore. Consent. Data fiduciaries are authorized to process personal data only for lawful purposes, contingent upon obtaining consent. This consent must be characterized by being free, specific, informed, unconditional and unambiguous. It necessitates a clear affirmative action on the part of data principal to signify agreement for the processing of their personal data for the specified and necessary purpose. The request for the consent must adhere to the following criteria. It must be presented in a clear and understandable manner, providing the option to access the request in English or any of the 22 languages listed in the 8th schedule of the Constitution. The request must include contact details for the data protection officer or an authorized representative to handle communications from the data principal. Additionally, a data fiduciary must provide a detailed notice to the data principal either during or before seeking the consent. This notice should encompass several key elements: explanation of the personal data to be collected and the purpose of its processing. Description of the data principals right, including corrections, withdrawal of consent, and the procedure for filing complaints with the board, and clarity on how a complaint can be lodged with the board. In cases where consent was given prior to the Digital Personal Data Protection Act's enactment, the data fiduciary must furnish such notice as soon as it is reasonably practicable. The notice must be presented in a straightforward language through a separate document, electronically or in a manner as prescribed. Data principles. When it comes to data principles, the Digital Personal Data Protection Act mandates that they can provide, manage, review or withdraw their consent through a consent manager. These consent managers, registered with the board, facilitate accessible, transparent and interoperable platforms for managing consent. However, the exact role and obligation of the consent managers remains unclear, including whether all data fiduciaries are required to engage with them for seeking consent and the mechanism they employ for performing their functions. Data principals also retain the right to withdraw consent at any time. Such withdrawal does not impact the legality of prior data processing based on the consent. Upon withdrawal, the data fiduciary and its processors must erase and cease processing the personal data unless retention is required by the applicable laws. Parental consent. It is also noteworthy that the Data Protection Act introduces the concept of consent of the parents, which encompasses the consent of a lawful guardian where applicable. Data Protection Board. Among the notable changes in the Digital Personal Data Protection Act, the most significant pertains to the establishment and composition of the bill. In the 2022 bill, the formation of the board was contingent upon the future regulations prescribed by the central government. However, in this recent redaction, the framework for the board's constitution is explicitly outlined. Additionally, the authority of the central government to establish rules as well as specific scenarios under which entities can be exempted from complying with the bill's provisions have undergone significant alteration. Evolving dispute adjudication. The Digital Personal Data Protection Act aids in a paradigm shift in the arena of dispute resolution, reflecting a nuanced interplay between the legislative framework and established legal mechanism. A noteworthy departure lies in the empowerment of the board to levy monetary penalties as specified in the schedule. It omits a prior reference to a maximum penalty ceiling of ₹500 crore, which was present in the 2022 bill, signifying a deliberate recalibration in penalty imposition. This recalibration highlights a meticulous approach that brings to the line penalty with the gravity of breaches, embodying a principle of proportionality. The appellate process too witnesses a transformative shift as it finds its recourse in the Telecom Dispute Settlement and Appellate Tribunal. This change instills the process with efficiency, outlining a defined window of 60 days for appeals from the board's decisions. Penalties. Penalties of up to ₹250 crore can be imposed for certain offences, including failure to prevent a personal data breach. The Act removed penalty of ₹500 crore cap on penalties for a single instance. Unlike the previous draft, the Digital Personal Data Protection Act does not enable affected data principal to seek compensation for breaches by data fiduciaries. Instead, the board can now levy penalties of up to Rs 10,000 for data principals not fulfilling their duties. While there has been praise reserved for Digital Personal Data Protection Act in terms of acting as an enabled standalone data protection framework, not everything is as rosy as it seems. Concerns arise from the fact that several provisions within the Act are still subject to determination made by the central government. This aspect raises valid concern about the potential for unchecked and arbitrary rulemaking, which could lead to uncertainties and potential gaps in the regulatory framework. Furthermore, for a legislation that is intended to protect the rights of data principals, it seems ironic that the Digital Personal Data Protection Act imposes duty on data principals. Similar to the 2022 bill, the Act also possesses the capability to provide exemption to the central government. However, in this iteration, these exemptions have been extended even more, perpetuating the absence of substantial criteria to counter excessive surveillance practices. The central government also retains the provision to exempt certain fiduciaries or classes of data fiduciaries from particular provisions, specifically including startups. The Act defines startup to mean a private limited company or a partnership firm or a limited liability partnership incorporated in India, which is eligible to be and is recognized as such in accordance with the criteria and process notified by the department to which matters relating to startups are allocated in the central government. The 2022 bill allowed the central government to assume the consent of data principals in certain situations, with no way for them to opt out through its deemed consent clause. The Digital Personal Data Protection Act has retained this provision, rebranding it to certain legitimate uses. The introduction of a transition period is vital to facilitate a smooth adaptation for the business. The Act introduces new and stringent obligation which could require significant adjustments from the data fiduciaries. Implementing the Digital Personal Protection Data Act without a transition period could lead to widespread non-compliance. Providing an ample transition window allows business the time needed to align processes and adhere to DPDP Act requirements, mitigating potential disruptions and ensuring a seamless transition to the new data protection landscape. Concluding the topic, the Digital Personal Data Protection Act marks a distinctive approach by India to safeguard personal data, reflecting the culmination of thorough discussions after its initial draft. This data protection law represents a crucial step in safeguarding personal data, addressing long-standing need in the context of increasing internet users, data generation and cross-border trade. In its entirety, the Digital Data Protection Act signifies India's unique stance on modern data protection, enriched by extensive post-draft consultation. While its provisions are less detailed than standards like GDPR, it mandates a significant shift in how Indian business approach privacy and personal data. However, the Digital Personal Data Protection Act is not immune from criticism. Some argue it could hinder innovation due to perceived strictness, while others contend that it might not go far enough to ensure individual privacy, primarily considering the discretionary power granted to the central government in personal data processing. The forthcoming rules through delegated legislation will play a vital role in shaping these aspects. A standardized process for rule release coupled with industry consultation as seen in amendments to information technology rules for outlining gaming would establish a robust data protection framework benefiting the entire technology sector in India. Thank you and have a nice day.